Welcome to part 2 of our conversation with Mark Schedler on Northwest Real Estate Forum. Mark is an award-winning attorney that specializes in the representation and arbitration and mediation for residential and commercial real estate disputes. Welcome, Mark.
Thank you.
So here's our part 2 conversation of the Form 17. We spent a little bit of time first talking about what a seller's obligation is and what the seller, how they should think of the Form 17. And you also mentioned that buyers shouldn't only rely on that. They really need to do their due diligence and inspections and all of that. So let's say a buyer comes down the road, and we've run into this recently in 2 different occasions, where the buyer comes in and says, I've had a major roof repair. It's clear that the seller knew there was a roof leak, and they lied on the Form 17. What does the buyer do?
Well,
besides call you?
Yeah, a buyer should hopefully have consulted with a lawyer before they bought the property to understand what they were going to do with Form 17 and their scope of due diligence as well. But at that point, to take your hypothetical, they want to get to an experienced lawyer who can not only tell them what the law in the book says, but how these cases go when a buyer sues a seller or a buyer looks for a legal remedy to the leak in their roof. And the fact is that very few buyers ever recover in court satisfactorily to them. I've never met a buyer who said that was the smartest thing I ever did was hire that lawyer and go get that money extracted from the seller, because it's a tremendous investment of money and time with a great deal of risk. If that same money went to just repairing the property and that same amount of energy just went to all the things they do in their life anyway, at the end of the same period of time, they'd almost always be better off and happier if they hadn't decided to choose a fight rather than to not choose a fight. And one of the reasons is that buyers rarely prevail in these claims because most of the problems that are the subject of the fight are determined to be something that a buyer could have figured out on their own, and that those cases are the ones where there is no remedy in court. The law in Washington State is about as close to buyer beware as you're going to see. The exception is that very hidden thing that the seller knows about that because of paint and putty and carpet and other things could not be reasonably discovered in a diligent investigation of the property. And there just aren't very many of those cases where you have that condition of the property and a seller who's willing to lie about it.
So if the buyer can be angry, the buyer can be upset, but they really need to balance the dollars and cents, the time and the energy of really what is the value and the cost.
Right. I think if we could take this subject back to the point where they're now just looking at houses, they haven't bought a house with a problem and they're disappointed, the best way that a buyer can protect themselves from a condition of a future property is this due diligence before they're committed to buy. It's a much better use of their time, energy, and money, and they will have a much greater amount of control over the process than they would over a fight. So what they ought to do if they're concerned about that is consult with people like you about what's available in the realm of due diligence in terms of videoing a sewer, what kind of expert should look at the roof, what sort of electrician person should take a look at the capacity of the electrical system, whatever those issues are, and then make a decision about how much money they want to spend and how much time they want to spend examining a property before closing. Most reasonable buyers come to a point where they go, you know, every house is going to have a problem, and none of them ever love you back. So I might as well just spend the money repairing whatever this house has than discovering the problem, because it's probably not going to change my decision to buy it. And that's that point at which the buyer becomes comfortable with not only spending the money on the due diligence, but living with the consequences of not doing everything they possibly could do in their due diligence.
Well, this is such valuable information for everybody on the buyer side and the seller side, and I really want to thank you because I run into this all the time. I know other professionals run into it all the time, and it hopefully will make some people sleep a little bit better. It won't earn you as much revenue because it's a very solid and rational approach, but I want to thank you, and we're going to have you back again.
I look forward to it.
Thank you. Thanks for watching this edition of Northwest Real Estate Forum. Remember, whether you're buying, selling, or sitting on the sidelines, keep watching for important information on topics that are impacting your biggest asset, your home. To learn more about this and other shows, please visit us at northwestrealestateforum.com or check us out on Facebook. While you're there, be sure to order your free copy of Neighbor Law, Fences, Trees, and Boundaries by Kara Jordan. You'll be surprised at what you learn. I'm your host, Patricia Wangsness. See you next time.